Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. As we look at the calendar, it is probably a very good bet that both sides in Idaho versus Coburger are working on their respective motions in limine, which are due to be simultaneously filed the 24th of February, with hearings scheduled to occur on April 9th, and if necessary, continuing on to the 10th of April. Might one or both sides file a motion in limine to exclude the other side's expert witness? For example, is it possible the state may file a motion in limine to seek to exclude Ray from testifying on behalf of the defense? Conversely, could the defense possibly file a motion in limine seeking to have Detective Mowery stricken as an expert witness? Well, to help to address this question, let's look at State of Idaho versus Ruben Daniel Diaz. This is a case that went to the Idaho Supreme Court. The opinion was filed April 6th, 2022, and it seems to suggest that not only is it possible, but it's very probable that such a motion in limine could be used to exclude the evidence brought to the table by a proposed expert witness. Page 1 of this ruling says, the state challenges the district court's order denying a motion to exclude expert testimony. The state filed a motion in limine to exclude Diaz's expert from the case. And it went into some of the reasons why the state looked to have the defense's expert, this was a doctor, prohibited from appearing at jury trial. We go to page 3. It says here that the state moved in limine to exclude this doctor's testimony, to exclude the expert's testimony, arguing it was irrelevant, prejudicial, and advanced a prohibited insanity defense. The name of the expert was Dr. James Davidson, who opined that Mr. Diaz was delusional at the time of the offense. The standard of review, paragraph 2, page 3, goes into what a motion in limine is and gives other clues here. It says here the trial court has broad discretion in the admission and exclusion of evidence, and its decision to admit evidence will be reversed only where there has been a clear abuse of that discretion. So that's a really high burden. If, for example, Judge Hippler decides to allow Ray or Detective Mowery or both to testify, it's going to be really hard to get that reversed on review because of this broad discretion standard. That's my opinion that I give. A motion seeking a pretrial ruling on the admissibility of evidence is known as a motion in limine. And according to the Idaho Supreme Court, page 3, Idaho courts recognize the importance of a motion in limine. A motion in limine enables a judge to make a ruling on evidence without first exposing it to the jury. It avoids juror bias, sometimes generated by objections to evidence during trial. So what we're seeing here is the Idaho Supreme Court talking about how important these motions are, that a trial court has broad discretion, and that, yes, based on the Diaz case where an expert was sought to be excluded on a motion in limine, this is possibly going to be the subject of what we will be seeing very quickly in a couple of weeks here when the parties begin filing their motions. This is Kathy. Thank you for joining us today.